have any doubts, you can mail to me also, or you can also you can speak to me on WhatsApp. You can chat with me. There's no issue at all. In the evening, you can speak to me, chat with me also if you have specific doubts on any specific case. Now, why I give a lot of importance to the Supreme Court judgments? As you know that in any system, any political system, whether you like it or not, the court is the last hope of any citizen of the country. You know, whether you are poor, rich, or middle class, it is, as we call it, the last bastion of hope. You know, when you fail at, say, every door, you think that it is the judiciary which is going to bail you out. So it is the last lamppost of hope. So it's also true in the US. Recently, Donald Trump has been given a lot of orders, like an Indian student who has been kicked out because he was doing some research on the PLO. So he was getting kicked out, but the court has said that no, I mean, he can't be deported before a fair process of law is put in place. Or even when they were trying to say those who are domiciles, so they will not be considered as citizens. So even in the US, with the kind of majority that Donald Trump has, and there also, you know, you'll find that judiciary has been a real bulwark of hope. So even in your main examination also, whether you are taking the IAS or in the interview, there would be a few questions on important court judgments. These days, for instance, this Justice Burma, you know, from whose house बहुत थोड़ा पैसा बाहरला माने जेतरे निया लागला थोड़ा पैसा बाहरला. So there is already a dispute whether it should be handled by the judiciary or there should be an impeachment proceeding. Have you understood the debate today? The debate is, as per the constitution, a judge can be removed for proved misbehavior or incapacity. Please note down. सबटी मन रखिथिबो impeachment पाई different authorities पाई different criteria अछि. Say for the president, it is violation of the constitution, and for the judges, it is proved misbehavior or incapacity. Proved misbehavior has nowhere been defined in the constitution, but generally it is construed as corruption. So in the case of Justice Burma, but in the case of Justice Jadhav, Allahabad High Court, जे कि बहुत उड़े माने pro-Hindu statement देथिला. So whether it is a case of proved misbehavior or not, it is not a violation of the constitution. Somebody will say. Can you tell me who was the first Supreme Court judge against whom an impeachment proceeding was initiated? क्या कला? कौन कला? See the removed Justice Sen. He is right that the judge who was removed was from the Calcutta High Court, Sen, Sumanta Sen. These are the things, the interview ko jibo, these are the things they will ask in depth. Understanding. So then they will ask you, why was he removed? If somebody can tell me, see, 100% say paibo, mane IS paibo, OS paibo, 100% paibo. The political science teacher ko pachara se koi period. See, what was the exact reason why he was there was an impeachment proceeding against him? Can somebody tell me? Se jetole advocate thile, when he was an advocate in Calcutta High Court, he was an amicus curiae. Lekha amicus curiae. Amicus curiae mane? Amicus curiae mane? Can somebody tell me? What is an amicus curiae? What is an amicus curiae? Anybody? देखो तो तुम केमती माने गोटे गोटे छोट छोट जिनस केम तुम झुंटुच बुझीपार तो कथा तुम सब पढ़ुच लक्ष्मीकांत पढ़ुच मु भी लक्ष्मीकांत पढ़ुची तुम मैंने देखो गोटे छोट छोट कथा केम तुम हाउ यू ट्रिप बैडली डू अंडरस्टैंड माय पॉइंट amicus curiae माने where the court appoints a lawyer to do investigation on their behalf. This is not amicus curiae माने a lawyer who is asked to investigate the veracity of a complaint, where the person appointed by the court to give a report on the veracity of a charge, on the veracity of a corruption charge. Veracity means truthfulness. बुझु तो माने धर गोटे riot हेछि हला गोटे riot हेछि. So the court will say, instead of depending on the police report, they will say जे कपिल सिब्बल को कहबे कि गोटे सीनियर लॉयर को कहबे जार गोटे बहुत हाई क्रेडिबिलिटी अछि तमे जाकरी गोटे रिपोर्ट दियो. So that person is known as amicus curiae, person who is considered to be a very high degree of integrity, very high degree of integrity, professional. So Justice Sen, when he was a lawyer, thank you. So when Justice Sen, when he was he was appointed as an amicus curiae in an arbitration case. It was a huge arbitration case. Seidre, the party concerned had deposited money into the account of the amicus curiae. बुझलो तो 5 कोटी की 10 कोटी टंका तंका अकाउंट रे amicus curiae अकाउंट रखते. So while the proceeding was going on, he used that money. He used that money for his purpose. But then, after a little while, after a few months, he deposited back that money. This was the reason for which an impeachment proceedings were there. Mane, बुझी पड़छो तो कथा. Mane, so it was a very interesting case where trust thila. Mane, he was trusted to handle. So question was, why did he use that money, which was not his own money? Why did he use it as a private money? So integrity is a very important issue. So सबुबले जो सुप्रीम कोर्ट जजमेंट हला कि मेजर हाई कोर्ट जजमेंट हला एउडा टिके भलो कि ध्यान दोथबो, and also the linkage with the article in the constitution. It's a proved misbehavior as la corruption. So the general interpretation by the court has been, the parliament has been, proved misbehavior refers to corruption. Proved misbehavior corruption, even supposing you make statements which are derogatory of the constitution, so it would be proved misbehavior. But generally, corruption cases. But I asked you a question: who was the first judge against whom impeachment proceedings were initiated and when? बुझ्छो तो कथा तबे केमति सब माडा खाउछो तुम देखुछो तो केते बुधिया बुधिया पिला सब. V Ramaswamy, please note down. V Ramaswamy was the first person in 1993. He was the first person against whom an impeachment proceedings was initiated. See, case ta thila when he was Chief Justice of Punjab High Court. When he was Chief Justice of he bought a number of things for his house, like carpets, like sofa, very expensive carpets and sofa for his house from a particular dealer from Madras at a very exorbitant price. That is why B. Ramaswamy, Punjab and Haryana High Court. He was Chief Justice of Punjab when the impeachment proceedings started for corruption charges when he was a Chief Justice of Punjab High Court. So 8 years hala so there was impeachment proceeding against him. Paisa khaichi mane public money te misuse karichi. So that time Narasimha Rao bailed him out. Otherwise se jaitla kamare jaitla Narasimha Rao prime minister thanti tanko se bail out kar एवढा टिके बने रखो जोड़ा सब important cases होच ना तो as I told you कोटे ना तमे inventory of the note कर रखा तो I will not repeat again. Inventory of important articles of the Constitution, inventory of important amendments of the Constitution, then inventory of important court judgments. Hala, ए गुडा करे टिके नोट कर रखी दबो और जहां नुआ आस्तुआ ऐड कर दो थो. There is no power on earth where you will have difficulty. बुझी पड़ सकता गोटे हला articles आउ गोटे हला amendments गोटे हला judgment आउ गोटे हला schedules आउ जो schedule अछि ए गुडा को ऊपर तमरो पूरा थरो थियो शेड्यूल 7 टा कोन शेड्यूल 9 टा कोन शेड्यूल 10 टा कोन शेड्यूल 11 टा कोन तो इन द थरो थियो माने आई एम जस्ट टेलिंग यू सबोल गोटा मन रखिथिबो जे तुमर प्रिपरेशन रे इते कॉम्प्रिहेंसिव हेथिबो जे तमे यू गो टू द एग्जामिनेशन माने very confident but there can be surprises एमती कथा नै जे तमे गोटा 100 ରୁ 100 मार्क मारे आसो तो you go there fully confident. Same economics ray. So I will send to all of you some of the articles which I consider to be, all of us should know. All of us should know. The pacharla kahaku je pacharla je 124A ta kon 124A ta kon what is 124A बुझी पड़ सकता था हाँ को
सर नेशनल जुडिशियल अपॉइंटमेंट
कौन था
नेशनल जुडिशियल अपॉइंटमेंट
Constitution of NJAC बुझी पड़ जो Constitution of NJAC which which amendment was it 19 and whenever it is struck down
2015
hello बुझो तो so सेउडा सब मन रख important articles वाट के मन रख बुझी पड़ जो article 38 टा कौन what is article 38 article 38 टा कौन distributive justice कौन सा आउट के बढ़ा दिया reduction of income inequality. Please note down article 38 hala mainly reduction of income inequality and elimination in opportunity. Elimination in opportunity. Try to understand this. Article 38 is very important. Article 38 2 kochi, it is the duty of the state to reduce income inequality. Economics economic inequality ko term कहते Gini index. Please note down Gini coefficient. It's called Gini coefficient. Gini coefficient. लिखी दियो एमती गुटे माने वर्ड आसो तुमको Gini coefficient is nothing. On a scale of 1, what is your inequality? If your inequality is 50%, so Gini coefficient is 0.5. So article 38 बुझी पड़ तो माने मोर एठी आसीबार मेन रीजन हला तम मन को टिके थरो करियो इच्छा आ टिके डेप्थ रे जिबा अच्छा नथिंग एल्स तमेडो सब बाकी सब पढी कि तुम सब पाई जिवो किछ असुविधा नै तो मोस्ट ऑफ यू हैव गुड स्टैंडर्ड्स टिके डेप्थ रे गले कोन होबो तमे तोर पोजीशन टा बेटर हबो फाइनली आमन जब जाउथुर परीक्षा दा अपन जाउथुलु 6 ऑफ अस हु गॉट थ्रू हमर केतुडो डाउट नथले जे हमर से जो लिस्ट हम नाट नथि माने वी नेवर यूज्ड टू गो टू यूपीएससी से लिस्ट ता नाट अछि कि रे कोठी पोजीशन ता अछि की आगे अछि की पछरे अछि that was not because of any false bravado it was because of our thoroughness बुझलो तो धर सोशियोलॉजी में पेपर नैतलु आई एम टॉकिंग ऑफ 77 सोशियोलॉजिकल थॉट रे गोटे थला पेपर थला गोटे बही थला रेमंड आरन तुम रेमंड आरन ता पढ़ी दीचो पूरा पढ़ दीचो ताले कोन से सोशियोलॉजी पिला तुम अधिक मार्क रख परिबो के मु अरविंद बेरा रवि सेनापति सब आईएएस पाइतलु all of us read that book thoroughly कोन बुझ कथा सब read a good book जिंदर रमेश सिंह हला इकोनॉमिक्स इट्स अ रीजनेबली गुड बुक ताको पूरा भलो करी नोट कर जोट तोरा डाउट अछि मत पचारे ताको दे सप्लीमेंट करियो इकोनॉमिक सर्वे रे संगरे कंप्लीट करियो पेपर कोन बाउच देखियो मैं एउडा कहूची कथा कोन एरा काहे कहूची तुम जरा कंप्रिहेंसिव सर्वे करछो ताले यू डू नॉट गो टू द एग्जामिनेशन विथ अननेसेसरी फियर कोनटा आसीबो माने यू विल नॉट हैव मच ऑफ अ सरप्राइज बुझी पड़छ कथा so so constitution so now what we'll do friends I'll quickly go through the court sofa ke अंदर I'll quickly go into the এটা নিতে চলা যায় কোড গেল এটা দ্বিতীয় বার না কোন So last time I had covered 6 cases. More quickly I'll just go through, then I'll go to the other 6. Okay. प्रथम जजमेंट थिला इलेक्ट्रल बॉन्ड स्कीम उपरे नोट कर दो इलेक्ट्रल बॉन्ड स्कीम उपरे थिला which was struck down by the Supreme Court because anonymity in electoral funding देखिए खाली गोटो लाइन anonymity in electoral funding is against the principle of right to know. Anonymity in electoral funding is against the principle of what? Right to know, which is part of Article 19(1)(a). कितना प्रिसाइसली है बुझ पड़छो तो इलेक्ट्रल बॉन्ड स्कीम इज एन एनोनिमस स्कीम तमे टंका देलो कि जानि पले तमे काहा को देलो की देला जाना पड़ा सो इट इज अगेंस्ट द प्रिंसिपल ऑफ व्हाट राइट टू नो ऑफ द इलेक्टोरेट हैज अ राइट टू नो तमर क्रिमिनल बैकग्राउंड कोन तमे कोडी पैसा खाइछो कोन करछो एउडा सब जानिया कथा जानिबो बुझले तो so this was the case. Okay, so the second case which I did was एटा टिके ध्यान रखतो एटा आसीबार चांसेस अछि सेकंड केस टा मोर इंपोर्टेंट फ्रॉम द एग्जामिनेशन पॉइंट ऑफ व्यू एटरला पावर ऑफ द स्टेट दीटा कथा पावर ऑफ द स्टेट टू receive royalty and tax from the mines without interference from the center. I'll again repeat what is this case. एइत्रा होची स्टेट रो राइट जदी हम स्टेट रे आयरन और खणी अछि तार जो रॉयल्टी और तार जो टैक्सेस या ऊपर स्टेट रो फुल पावर्स अछि So basically, and the center cannot intervene there. आगुर कोन होतला सेंटर मध्य से टैक्स रे शेयर करतला. So basically it is a case of providing fiscal autonomy, fiscal federalism. Fiscal federalism. What is fiscal federalism? Fiscal federalism means giving autonomy in financial matters. Giving autonomy to financial matters. In financial matters to the state. Are you all following me? Be very precise in your answer. Giving financial autonomy to the state without central government interference. Agur kon question thila te jehetu there are parallel provisions. Kahin ki confusion hotla? There is a provision on mines in central list. There is also a provision in the state list. So question hota the ditanger power achi. How can you say that the center has full powers? So Supreme Court said no, state has full powers because mines come under a state subject. Please note down. Jami, Pani, au Khani. Jami, Pani, au Khani. Land, water, and mines. These are the exclusive purview of the state government. And law and order. Please note down. And law and order. And law and order. It is the exclusive preserve of the state under the state list. Kintu, please note down. You go to a different level altogether. Are you all getting me? So out of these four things, areas that I told you, please note down, land re, ABB, state full responsibility. Full authority. Water re madhya full authority. But this position was not so clear in regard to mines and industries. Please note down, mines and industry. Mines and industry. Mines of industry, there are parallel provisions both in the state list and central list. Center regulation of माने जदि खनि तमर एठी अछि so they can regulate जे तमे केते खनि exploit करूछो, is it getting is it going to affect the environment? All these things the center can look into. Are you getting my point? So therefore, so the Supreme Court said yes, they can control they can look into the environmental aspects, but as far as the money aspect is concerned, it is the prerogative of the state. This judgment is likely to come. Note my request to all of you is jodak so likely question hoch tomar main pai tame adha to pressure note karo tale tomku seithi you don't have to articulate the answers there. Are you all following me or not? जो गुड़ाक likely question आसीबार अछि मुझा कहू तुम likely question कहूची हैला से गुड़ाक तमे अधो तो पेज नोट करतो सेठी बसिकरी तमे 200-250 सेटा को 250-200 करी रेडी के रखतो आ सेती खाली पढियो रात रे. अरे गेटिंग माय पॉइंट मु जमा आ किछि पढे नै मु नोट्स कर दी थाए रात रे ता दिन पढी के तापर मु सुए आराम रे तेनु एंड देन आई थिंक इट ओवर. अच्छा अच्छा एउडा पढियो गलो संग से करो आस करके आसी. आर यू ऑल गेटिंग और नॉट? तमे सेठी जिमने जाई कि तमे बसी कि तमे आइंस्टाइन बेले भाबे चेष्टा करो ना कि तमे सेठी बसी कि न्यूटन हो चेष्टा करो बुझले कि आर्किमिडीज हो चेष्टा करो. आर यू ऑल गेटिंग मी? As a researcher, supposing I do a lot of research, I can think over it. 5 दिन भाभी भी लेखी भी अमु करबी. But you don't have that luxury. You are not a researcher there. You should have ready-made answers. मु तो डाकुची कहेंगी so that you know the construction. Are you getting me? So this is a likely question. एटा है साला तापरे एटा मु गुड कहितली अरे एटा आउट कोड कहिते देवेंद्र सिंह वर्सेस स्टेट ऑफ पंजाब कौन कही सबकास्ट एटा भी टिके मन रखो एटा होचे अनदर क्वेश्चन व्हिच इज लाइकली टू कम मोटा सजेस्ट कर तुम मन को जो मन तुम दोच मेन परीक्षा दोच हैला मु तुमको एटा आइडेंटिफाई कर दोची तमे 250 गोटे लिखिकी मत तमे मेल कर दियो लेट मी हैव अ लुक हैला प्रैक्टिस कर दियो प्रैक्टिस तुम जदि दौच टेस्ट दौच तुम दे देले मु देखि दियंती कि तुम करछ आंसर करछ देखि दे हैला तो तुम खाता वाला देखिले जानी परबी जे तुम कोन होची तुम जो लिखुछ ठीक रहउछ तुमरो किंतु कंक्लूडिंग भलगिरी करि पड़नो मोस्ट ऑफ यू डू नॉट कंक्लूड वेल but this is my impression of not only you माने most of the good students also have this particular problem किम end करिवो किम ताको करिवो सेटा टिके all those of you who are taking the main examination particularly एटा टिके प्रैक्टिस करके तुम एटा गोटे this is one question you keep it हैला तो आंसर करिवो एटा को आंसर करिवो हैला तो तुम दोच परीक्षा ना थरो दे जे दोच परीक्षा जे न दोच भी मत पठा बोल आंसर देखियो टिके let me see the kind of answers hala tumi to ke jon do to pariksha how many okay so you please write it down this answer tapare eita gote another very interesting thing ei jo pornography child pornography whether it will attract the POXO act child pornography whether it is going to attract so agro ये system थिला जे as long as you store it and you don't disseminate it was not considered a crime please note down as long as you store it and do not disseminate it do not spread it do not send it to your friends for liking kariya pai then it was not a criminal offense but in this judgment the court has very clearly said that it would be a crime if you have not deleted it you can upload it but if you have not deleted it even if you have not disseminated it would be proof that you have a future intention to disseminate please note down this is very important there are two things one is even if you do not disseminate there would be a suspicion that you have an intent to spread, to disseminate it. How would hala? How would a quota coitli? Monopaga, Ponda con coitla, would a con coitli? Huh? How would coitli con? How would a con important kata coitli? Third party in con coitli setago? Seta coitli. Safe harbor clause. Safe harbor clause. Please note down. Safe harbor clause. अरे एगुड़ा माड़ खाइबो इंटरव्यू रे पचारिबे अरे व्हाट इज ए सेफ हार्बर क्लॉज बोला माडो सागे सागे रे से जेमती जसप्रीत बुमराह रो जेमती हला यर्कर रे एकदम पूरा सफा हलो तमे तब सफा हो पूरा व्हाट इज ए सेफ हार्बर क्लॉज को very good second panel third party खास पर तो सब रेस्पोंसिबल सेफ हार्बर क्लॉज हला जे तमे जदी थर्ड पार्टी हे करी गोटा होस्ट करछो गोटा मटेरियल होस्ट करछो जदी इट इन्वॉल्व्स चाइल्ड I'll call you up, Raj. Huh? So, if you are a third party and the material is with you and you have disseminated, so agru thila je tomar kichi responsibility nahi kichi. Tomar sithre kichi culpability nahi. Because somebody has sent it to you, you have only acted as a post office. So the Supreme Court said, no, you are not a post office. When you notice that child pornography is there with you, delete it. It's a very, very important judgment. It's a very, very important judgment. The third party जो आराम रे बसुचना नाही मो पखु आसला मु कोन करबी सर मो पखु वो कागज भितर से पकई देला मु कोनटे करिवि ना यू कांट बी सो इनोसेंट अबाउट इट ओके सो इट्स अगेन अनदर केस जोटा की आसीबार चांस अछि बुझलो तो वी गो टू दी फिफ्थ वन रे किछि नहीं जोटा होची डिस्ट्रीब्यूटिव जस्टिस माने व्हाट इज द डेफिनेशन ऑफ प्राइवेट प्रॉपर्टी कम्युनिटी रिसोर्स रो डेफिनेशन कोन कम्युनिटी रिसोर्स रे डेफिनेशन होची जे इट विल इंक्लूड प्राइवेट प्रॉपर्टी आल्सो बट विथ रेस्ट्रिक्शंस कोन हला जो डिस्ट्रीब्यूटिव जस्टिस हमारा आर्टिकल 39 नोट कर दिए आर्टिकल 39 रे जो डिस्ट्रीब्यूटिव जस्टिस जो क्लॉज ता अछि कोड अछि 39 बी रे अछि डिस्ट्रीब्यूशन ऑफ सेटा मटेरियल रिसोर्सेस बोली कहूचे ए जो मटेरियल रिसोर्सेस कहूचे will it include private property or not so the court has said yes it will include private property but not in a sweeping manner it you have to see जैसे जो प्राइवेट प्रॉपर्टी निया होची सेते पब्लिक पर्पस हबो कि नाही माने इफ ए प्राइवेट प्रॉपर्टी इज टेकन अवे एंड यू से नाही सर किछि पब्लिक पर्पस पे नहीं नांती तालते कोर्ट विल गो इनटू दिस हैव यू अंडरस्टूड जरा तमर जगह खंड अछि तोर पांचटा गाड़ी अछि सरकार कर तुम पांचटा गाड़ी के बुरचो चारटा गाड़ी हमें नहीं जो आमे हमर सरकार के हम सो द कोर्ट विल सी वेदर इट इज अ पब्लिक पर्पस और नॉट आर यू ऑल गेटिंग मी बुझी पड़छ तो नहीं सब मन रखिए पब्लिक पर्पस गुड इवनिंग सर यस सर okay sir okay sir okay sir I'll call you up sir I'll call you up sir. Yes thank you से बुढ़ा जाक सबू संध्या बेला किसी काम नहीं सर रिटायर्ड लोक यू विवेक पट्टनायक 66 बैच से आरंभ कला माने अध घंटा घंटा मोर सडू जे तरुण कांति मिश्र चीफ सेक्रेटरी से फोन टा कला माने घंटा काम किछि नहीं ना स्त्री शुणुची कथा ना पुओ शुणुचंती कथा के स्त्री मन तो सुनिबार प्रश्न उठुनी बुझल त आउ तेडू माने एमिति मोर अवस्था ए संध्या हला पर गोटे पर जानि क्लास पास नोचु ता परटू गोटे पर गोटे आरंभ हो गला मुझे नाटा देखला कि जानी गला से कहते अरे तू केतले फ्री अच्छु माने सब दुनिया कथा सब अच्छी मजा कथा अच्छी क्रिकेट अच्छी सिनेमा अच्छी सब कथा अच्छी से तो ससुर थिला बेले 1.5 घंटा हम बचेला बुढ़ा 1.5 घंटा फोन कर कोठू कथा सब कौन लंडन रे करूथली केमती पढुथली को झियो केमती लाइन मारुथली कोन कि बुढ़ा माने करा हरियाण माने से दृष्टि माने मु कहा को विशेष बोर करें तमौटी बोर करे पाठ पढ़ेबारे अदरवाइज इशू बोर फॉर धंधा न था भारी देखो वी स्विच ऑफ कर दिली सो द क्वेश्चन एसेंशियली इज जे प्राइवेट प्रॉपर्टी with restrictions but basically please remember but this has established the concept of socialism please note down this is very important ए जिनसटा टिके मन रख पंडा ए जो जजमेंट अच्छी ए जजमेंट ए जो एटा टिके मन रख प्लीज ये सोशलिज्म आओ व्हाट इज द इंटरप्रिटेशन ऑफ द सुप्रीम कोर्ट ऑन सोशलिज्म प्लीज नोट डाउन ए पर्यंत गोटे डेफिनेटिव व्यू पॉइंट सुप्रीम कोर्ट देई नथला कि नोट कर वेरी वेरी इंपोर्टेंट टिल दिस जजमेंट बाय द चीफ जस्टिस ऑफ इंडिया जस्टिस खन्ना in Dr. Balram Singh versus Union of India this is one question which is likely to come eta bahut important all of you please write an answer on this I'll give the question just now write the question socialism and secularism are inalienable. 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 INALINEABLE. Socialism and secularism are inalienable. Unable features. Inalienable माने विच्छेद करियो. Alienate माने विच्छेद करियो. To alienate. ताको अलगा बसे दो. Alienate. Inalienable features of the Indian Constitution. Which Supreme Court judgment has decided on this issue and on what basis? And on what basis? A question ta hala auto read karo. All of you please आज घर को जाइगिरी काली मते एटा आंसर पुटो in 200 words. कौन क्वेश्चन टा को read it. Inalienable Constitution. Which Supreme Court judgment decided on this issue? एटा को आंसर करिया पे टिके खाली मन रख स्ट्रक्चर टा मन रख. प्रथमे तमे कहिवो जे these two words were included in the preamble in 1976 through the 42nd Amendment. Open with that. Open with that. Hala. This was challenged by Dr. Balram Singh. Invoking that if socialism is the basis of government working, then it will restrict economic activity. It will restrict economic activity of the private parties. Author कहिए हाँ कौन कहली ना कौन कहला allegation थिला जे if socialism is part of the constitution भले के लिखा part of the constitution it will restrict economic choice of the government and affect private sector enterprise. And affect what? Sector enterprise. Socialism mane kono? Try to understand this. This is a question which is very likely to come. It is very likely to come because this is a judgment in 2025. Socialism, please note down, socialism in the conventional sense. Socialism in the conventional sense. Socialism in the conventional sense means property belongs to the state. Property belongs to the state and the public sector undertaking would be primarily responsible, for major economic activity. Like pala dire, author koche, kon lecture kuja lecture. Socialism कौन कहली आउथर पढ़ दो प्रथम कथा हला जी प्राइवेट प्रॉपर्टी हला देयर इज नो प्राइवेट प्रॉपर्टी बिलोंग्स टू द स्टेट प्लीज नोट डाउन दिस इज गोटे कन्वेंशनल सोशलिज्म रो मीनिंग हला प्रॉपर्टी बिलोंग्स टू द स्टेट एंड द मेजर इकोनॉमिक एक्टिविटी will be done by public sector undertaking because, please note down, because it will promote public welfare and will not be driven by profit motive. Let me explain this. बुझी पड़तो कथा काहे किमते कहउतले सोशलिज्म जो कंट्री माने सोशलिज्म रे विश्वास करचंती से माने भाबंती जदि प्रॉपर्टी प्राइवेट हातु गला तार ऑब्जेक्टिव हला पैसा बनेबा धंदा करी पैसा बनेबा किंतु तमे जोटे पब्लिक वेलफेयर चाहूचो जे गरीब लोकंगर वेलफेयर हो ताहले it is only the public sector which can do that. Are you understanding the ideology itself? This is conventional socialism. तापर लिखो however in a mixed economy there is healthy balancing between government and private sector activities. Government and private sector activity, which is exemplified by the slew of SLEW, by the slew of public-private partnership, by the slew of what? Public-private partnership, which the Indian government has been resorting to, since economic liberalization. Have you understood now? What Chief Justice Khanna is saying, आमे जेते बेले भारत तो स्वाधीन हला आमे गोटे सोशलिज्म को गलु and predominantly resources were controlled by public undertaking. आमे नहीं नथलु जे property is of the government. So there was a concept of private property. Please note down. The concept of private property was never obliterated in India. Unlike China, unlike USSR, unlike Cuba. बुझे तो इंडिया रे सबुले गोटे प्राइवेट प्रॉपर्टी रिकॉग्निशन थला एंड दैट इज व्हाई यू हैड आर्टिकल 31 राइट टू प्रॉपर्टी आर्टिकल 31 राइट टू प्रॉपर्टी रहला ते नोट करो सेटा तो राइट टू प्रॉपर्टी रहला सो मेनी पीपल थॉट दैट व्हेन राइट टू प्रॉपर्टी वाज रिमूव्ड एंड 300A हैज कम आर वी गोइंग बैक टू सोशलिज्म बुझी पड़तो कि नहीं सो मेनी पीपल थॉट दैट वी आर गोइंग बैक टू socialism कहेंगे ना right to property वर्तन नहीं अरे बुझ पड़ो right to property. So Chief Justice Khanna is saying that in India socialism is to be understood by our concept of a welfare state. But though we are saying that we are a socialist state, but the driver of the socialism is welfare and distributive justice. Please note down. Driver of welfare ta kono na distributive justice. बुझी पड़छो कि नहीं जो मैं 90 परसेंट मत पचार रुपए बुझी पड़छो ये जो ड्राइवर था सोशलिज्म ड्राइवर था कोन वेलफेयर एंड डिस्ट्रीब्यूटिव जस्टिस. So unlike socialism जोटा which believes in equity, please note down, which believes in equity, India believes in distributive justice. आमे इक्विटी समस्त समान बोली कौन में सोशलिज्म कॉन्सेप्ट है कौन नो प्राइवेट प्रॉपर्टी खाली पब्लिक सेक्टर अंडरटेकिंग रहइबो एंड देयर शुड बी इक्विटी. तीनटा फीचर कौन कौन तीनटा फीचर प्राइवेट प्रॉपर्टी पब्लिक सेक्टर अंडरटेकिंग एंड थर्ड होची इक्विटी. मिक्स्ड इकोनॉमी रहला मिक्स्ड इकोनॉमी प्राइवेट प्रॉपर्टी रहइबो प्राइवेट सेक्टर रहइबो पब्लिक प्राइवेट पार्टनरशिप रहिबो आउ डिस्ट्रीब्यूटिव जस्टिस रहिबो so this is the concept of a welfare state so ei judgment बुझी पड़छो तो कथा हां so therefore secularism ऊपर किसी डिबेट नहीं माने secularism किसी डिबेट नहीं डिबेट होची सोशलिज्म ऊपर जे सोशलिज्म किंतु तार जो बलराम सिंह जो आर्गुमेंट दिला जे तमे कहबो जे हमें so you can always say that when Nehru insisted on socialism to be incorporated in the preamble, Dr. Ambedkar opposed it. Eighth में Ambedkar opposed कले जे the constitution must not say what economic system India should adopt. Please note down. Note करो. This is very important. Debate टा हला नेहरू अंबेडकर भितरे जे नेहरू कहले आमे सोशलिज्म टा भर्ती करिवा सेन कहला आमे जो लाहौर कांग्रेस हेतला 1929 रे प्लीज नोट डाउन लाहौर कांग्रेस रे 1929 जो हेतला लाहौर कांग्रेस रे कांग्रेस जर प्रेसिडेंट थिले जवाहरलाल नेहरू he said India should be a socialist state so when he came back from Lahore गांधी तो कहले तुम की तुम कहला जे एटा कहया पे he was very unhappy with Nehru माने नेहरू टिके रसिया फसिया बुली के आस्तिले तको से कहले हम गोटे सोशलिस्ट स्टेट करवा से कहले नहीं नहीं यू कांट सो अंबेडकर माने ताका जो मेन डिबेट हला नेहरू का संगे अंबेडकर कहला ना नो कॉन्स्टिट्यूशन एक्सेप्ट द कॉन्स्टिट्यूशन ऑफ यूएसएसआर कहूची कि वी आर अ सोशलिस्ट स्टेट प्लीज नोट डाउन एक्सेप्ट यूएसएसआर 1919 रे तल कॉन्स्टिट्यूशन हला and China in 1949 ए कॉन्स्टिट्यूशन रे प्रीएम्बल रे लिखाई दिला जे एटा सोशलिस्ट स्टेट बुझी पड़छो कि नहीं आर यू गेटिंग माय पॉइंट से कुछ वी आर नॉट लाइक यूएसएसआर और वी आर नॉट लाइक चाइना वी आर अ डेमोक्रेटिक कंट्री एंड इन डेमोक्रेटिक कंट्री डेमोक्रेसी रा मेन फीचर हला चॉइस प्लीज नोट डाउन फ्रीडम ऑफ चॉइस प्लीज नोट डाउन फ्रीडम ऑफ चॉइस not only freedom of choice of what you speak, it also includes freedom to do whatever business you want to pursue. This is Article 19(1)(g. Lekho, Article 19(1)(g. अरे मने पुछनो नहीं Article 19(1)(g कौन कहूची? You have the freedom
of
profession business. It again, it's an economic freedom. So that is why Ambedkar differed with Nehru. Je ame jodi 19(1)(g rakhuche, then how can we say that we are a socialist state? Ultimately, he won the debate because Sardar Patel supported Ambedkar at that time. Though Nehru had a lot of chamchas behind him, like Jayaprakash Narayan and all, many people indirectly supported him. But ame tore India le independent hela. There was a completely two different factions. Gote hela Ambedkar, Patel, Rajendra Prasad, एमन गोटे ग्रुप रहिले, राजाजी एमन गोटे ग्रुप रहिले, एगुडा खोजनी पूरा टोटली कैपिटलिस्ट मॉडल. आउ गोटे पट रहिले नेहरू हरिका रहिले, नेहरू रहिला, जयप्रकाश नारायण, राम मनोहर लोहिया एगुडा सब रहिले, एगुडा सब सोशलिस्ट पाए रहिले. बुझछो तो कथा. सो एई दि जनकर जो विवाद रे से कहला गोटा करदो सोशलिज्म टा रखे दवा प्रीएम्बल रख दवा बट दैट वाज नॉट एग्रीड. आर यू गेटिंग माय पॉइंट? सो एटा पर तमे जो नाउ यू कैन आंसर दिस क्वेश्चन बट आई वांट लिटिल डेप्थ इन द आंसर. खाली इनती एटा डेफिनेटली गोटा लाइकली क्वेश्चन. नाउ लेट अस कम टू Anshuman Rathore versus Union of India. एटा होची रेगुलेशन ऑफ मद्रासास. एटा टिके मन रखो रेगुलेशन ऑफ मद्रासास. माने मेन इशू हला जे if there is a minority religious institution like a madrasa, can it be funded by the state? It hala main issue. If you have a minority institution, can it be funded by the state? Tara madrasa ku tame madrasa they are disseminating knowledge which is predominantly for promoting Muslim religion. Okay. So issue before the court was जे तमे जो madrasa chalichi, say madrasa, will it not go against the whole concept of fundamental rights? So the earlier judgments of the court was, if you are segregating education on religious grounds, so you cannot fund it, and that is how the UP government withdrew all the grants which were being given to the madrasa schools. So Seitako Supreme Court has struck it down. Supreme Court kohuchi je by giving money to this minority institution, tame promote karucho minority kara education ta, so that they can be at par with the mainstream community. Please note down, there are three things in which the Supreme Court has been giving controversial judgments. Gotala reservation. Please note down. Gotala reservation. Not only reservation, and reservation in promotion. Not only at the entry level, but also at the promotion level. Mane tome tomo under ji kamo karchi, tome 10 barsh par dekhalu se tomar boss hi jaisi. So reservation in promotion, but surprisingly, the court has upheld all these actions. Please note down, it is a very important aspect of Supreme Court judgments. I don't agree with this at all. Okay. Tapare, the second very important thing is, creamy layer is not applicable to scheduled caste. Creamy layer is not applicable to scheduled caste. It is applicable to OBC, but it is not applicable to scheduled caste. Again, that's a very controversial judgment. Are you all getting me? Now, when it comes to minority and scheduled caste and scheduled tribe, suddenly Supreme Court bahut dani log hai jauchi, bahut udar ban hai jauchi. So many people believe that the decision of the Supreme Court to promote reservation is against the concept of merit and competition. Please note down. It is against the concept of what? Merit and competition. Tome kocho right to equality havo. Article 15 kocho samastu equal opportunity milibo. Equal opportunity milibo tahale reservation ta kimti havo. Are you all getting me? Or are you all getting me? So this is one area in which the Supreme Court has always been very soft towards the scheduled caste, scheduled tribe. The second area in which Supreme Court has always favored is for the minorities, religious minority, Muslim. Sabbubale judgments are pro them. But this is again a very flawed judgment. It's again a very flawed judgment. So how can you fund a minority religious institution? Tell them that Sikh manukar jo school achi, taku diyo paisa diyo. Are they giving money to? They're not giving. It is run by the Sikhs themselves. Are you all getting me? So anyway, so this is eta question samane. Eta samane question positive secularism. Please note down. Question asibo. What is positive secularism? What is positive secularism? What is positive secularism? Which judgment has upheld this concept? Please note down, a water for the first time, a judgment issue is. Please note down, positive secularism. Eparanto कौन सी judgment रे positive secularism water use ही नहीं. Positive discrimination. Please note down, affirmative action, positive discrimination है, किंतु positive secularism है ही नहीं. Positive secularism, note karo tome. Positive secularism allows the state to, it note karo pura line ta. Positive secularism allows the state to treat some persons differently so that everybody becomes equal. द्वितीय कथा हला state should take, please note down, state should take active steps to treat minority interests on par with secular institution while retaining their minority character. ए दीटा लाइन तमे प्लीज नोट कर रखो कारण तमर आंसर रे ए दीटा होची ऑपरेटिव पार्ट होची जो मन सब परीक्षा दबो तमे नोट करो ए दीटा आउ थर्ड टा formal equality is contrary to constitution's vision of a just social order. So दीटा कॉन्सेप्ट आसु तमे भलो के ध्यान दियो टिके कारण ए आंसर उडा कर देखो जदी तमे एगुडा कर ठीक वर्ड यूज न करूचो तो भारी डिफिकल्टी हो. So two concepts have been introduced here. Gotala positive positive secularism. The second concept lakhoiti substantive equality. Please note down substantive equality. अरे बुझो कि नहीं एरा सब माने वर्ड रा प्ले हेची बुझो तो आर यू ऑल गेटिंग मी amara the bare reading of a constitution means equality. So te note karo eta tome answer to tome dita layer न देखिबो देदो तार 8 मार्क पड़छ सांगे फुल मार्क पाइबो आंसर बुझी पड़छ तो आंसर ता एमिति हबो जिमिति तार जो मेन जो थ्रस्ट आसी जजमेंट आछो कोन हला प्रथम हला जे फॉर्मल इक्वालिटी इज कॉन्ट्ररी टू the constitution's vision of a just social order. आमे तो just social order देखुचे promoting socio-economic justice for all. So that social order, just social order will not come if everybody is equal. कारण जब समस्त equal हे गले ताले जहार पैसा আছে से आहुरी भलो करिवो जे रिच से रिचर होबो. So say the base one substantive equality concept. Substantive equality is aimed at producing equality of outcomes. Please note down. What is substantive equality? It is substantive equality is aimed at producing. What is substantive equality? Substantive equality is aimed at producing equality of outcomes through different types of affirmative action and state support. It is lekho bhalogiri. It is bhalogiri lekho bujo eta ko. Buji porcho eta buji porcho nai. Mane ultimately tar outcome ta important hochi. Mane khali equality jete karibo tale equality of outcome hoben na. Samo jodi ame equality treat kariba tale equality of outcome hobo ki? जदि हमें अनइक्वल लोगों को अनइक्वली हमें ट्रीट करिवा ताहाले जायकि इक्वालिटी ऑफ आउटकम आसो. अरे जदि शेड्यूल कास्ट लोगों को हमें ओई फ्री दबा स्कॉलरशिप दबा तब खाइबा फ्री दबा ताहाले तार इट इज पॉसिबल दैट देयर वुड बी एन इक्वालिटी ऑफ आउटकम. अमेरिका रे कथा करछो प्लीज नोट डाउन सेटा को सने पॉजिटिव डिस्क्रिमिनेशन कोड सने इक्वालिटी देउना इट्स नॉट रिजर्वेशन नाही. प्लीज नोट डाउन in the US there is no reservation. Please note down. Question asibo je what is the difference in the approach of the US Constitution to Indian Constitution in matter of equality? In the US Constitution, it recognizes the role of affirmative action. Please note down. It recognizes the role of what? Affirmative action. It recognizes the role of what? Affirmative action. Affirmative action कौन हो? Scholarship दवा, free बही दवा, loan दवा at low rates, free food दवा, subsidized food दवा. This is called affirmative action. whereas positive discrimination माने तमे reservation करो. Please note down. Are you following me or not? दीटा democracy अच्छी. दी type of democracy चलची. कुत्ते democracy कहउचंदी affirmative action करो. Affirmative action doesn't mean reservation. Please do not confuse that. Many times teacher will say, "Saman katha to sir ko." Saman katha no. Affirmative action is you are encouraging somebody. जे मु तुमको फ्री खाइबा को देबी तमे आसी पढो तुमको भलो फूड दबा बही दबा फ्री दबा यूनिफॉर्म फ्री दबा रहिया फ्री हबा. These are affirmative action. But positive discrimination aims at equality of outcomes through discrimination. Are you following me? This is extremely important. तमे जेपन न बुझी ए कथाटा एटा होची सूक्ष्म कथाटा. Positive ए जो कोन कहलो substantive equality हला जे equality of outcome में आमे जेमिति गोटे दौड़िया पई गोटे छोट पिला कहबे तू 10 मीटर आगे रह. So that there is equality of outcome. Are you all getting me? So this is गोटे हला substantive equality आ गोटे हला positive secularism. ए पेज को भलो करी मन रखो. बेटा क्वेश्चन आसीबो देखिबो. एटा क्वेश्चन आसीबो. आ गोटे लास्ट लाइन लिखो. Article 21A has to be read in harmony with the rights of minority under Article 31. Please note down. Article 21A, जो right to education. Please note down. मैंने एक केस टारे main argument थिला. Please note down. The argument was Article 21 is right to free education. Right to free education to everybody. जो दे right to free education समस्तों पे अच्छी पूरी कहीं positive discrimination होगा. अरे बुच्चो नहीं कथा. The argument is very powerful. जो दे Article 21 कहला तुमको free education दिया जाऊँची पूरी तुमको discrimination कहीं करा जीवो. सर कोच दे नहीं. That has to be read in harmony with rights of minorities under Article 31. तमने promotion of right, please note, promotion of rights of minority of the minority. Minority right को promote करिया पे 21 एटा को nullify करिया पड़िबो. तो बुझी पड़तो तो माइंड टा केमते काम करूची. से माने चाहूचंती promote करिया पे minority. एटा दे सीटा को आर्गुमेंट को. बुझी पड़तो तो कथा. को कोन को. So it is the question as you तुम कितने end करियो. Now the question is how to end it. बुझी पड़तो तो. But the main challenge was that if right to free education is a fundamental right to everybody, how can there be a further discrimination of religious minorities? Is that clear or not? So the court has tried to look at it by invoking two concepts, namely positive equality and positive secularism. It answer karo. तुम्हारे main पर क्या तो चढ़ा answer करो. एक क्वेश्चन answer करो. The court has tried to nullify this argument that 21A cannot trump 31 by invoking two concepts. What are the two concepts? Substantive equality and positive secularism. Are you getting my point? बुझी पड़तो तो. So how do you end it? It है court of judgment है तमे किंतु आडमिट करियो. तमे कोन चंद्रचूड़ ऊपर अछो ना तमे कोन नरेंद्र मोदी तो नरेंद्र मोदी है जगह तमे लिखि परिबो जे while when you can write like this, while the judgment is an attempt, while the judgment is an attempt to bring equality of outcomes between communities which are differently placed. which are differently placed in terms of income and opportunity. In terms of income and opportunity, it also goes against the concept of merit, which is the spring well, of dynamic democracy, as in the USA, through affirmative action. केम लागला सेंटेंस टा? अरे सेंटेंस टा केम लागला? भलो अछि एमती करिकरी ताको बुझो तो तुम एंड करो सेमती किछि असुविधा नै माने जदि तमे माने जदि लढे को चाहू छे केस टा पे यू कैन राइट लाइक दिस देयर इज नो प्रॉब्लम को हां
religious instruction है common 100 institution तो सेमिनार एंड कॉमन 100 कोचिंग इंग्लिश में रिलीजियस इंस्ट्रक्शन दोन
केते तो कहचे केस थला ना ये करथला हमर कोन ता नाटा नहीं नहीं सुब्रमण्यम से जो आपर जे राइट टू इंफॉर्मेशन एक्ट रे से जो स्थिलोगटी मो ता नाटा को बंकर राय रो वाइफ की रॉय माने अरुणा राय had said this, or there is a case of Aruna Rai. Look, note करो Aruna Rai versus Union of India. जी तमे गोटे पब्लिक इंस्टीट्यूशन रिलीजियस ट्रेनिंग दे परिवो नाही कि तो सुप्रीम कोर्ट मानला नहीं अरुणा राय वर्सेस यूनियन ऑफ इंडिया बहुत गालमी करछथि सुप्रीम कोर्ट रो बहुत गालमी जजमेंट्स हो अछि सुना माने इट्स अ वेरी गुड क्वेश्चन यू हैव आस्क्ड now they have said supreme court has said जे सेतरे खाली रिलीजियस इंस्ट्रक्शन रहइबनी सेतरे मध्ये साइंटिफिक टीचिंग रहइबो सेतरे ताकर इंटरफेरेंस हबो प्लीज लिसन टू मी वेरी केयरफुली now the stand of the government जदि हमें पैसा दोउछु ताले they can bring reforms into your syllabus while you have freedom but there would be suggestion for reforming the syllabus which will include teaching in science arts but the reality is छोड़ा छोड़ा खाली रिलीजियस कथा पढुचंती भारत विरुद्ध रे केमिति करबा सिसा खाली इट इज अ हॉटबेड ऑफ एक्सट्रीमिज्म सब बदमाश छोटू बाबू माने इफ यू वांट टू हैं एबे कोच रे अच्छी समझ एनीवे तब एटा उटा सुना दिस एन इंपोर्टेंट जजमेंट इट्स एन इंपोर्टेंट नो आई हैव नो प्रॉब्लम इन because there are a lot of evidence to that effect but it is a imiti kotha nai je sabu all madrasas are doing like this but most of the madrasas are teaching religious extremism there is no doubt about it but I am not trying to brand any particular community with any black brush but most of the extremist activities have emanated from this community there is absolutely no doubt about that and you have to control them sethe kichi koibar but that my concept of democracy doesn't extend to tolerating people who are sabotaging the interests of the country माने तमे सरकार तो पैसा नबो पैसा नै कि पुनी सरकार का विरुद्ध करिवो that's not a fair call that's not माने गोटा फ्रीडम ता माने फ्रीडम माने नो जे ह्यूमन राइट्स कमिशन रे त 500 लोगों को नानी दला तांको अरेस्ट करिवोनी कि तांको टॉर्चर करिवो so I mean they go to the other extreme of freedom that is how they have outlived their anyway तो बुझिगर कथा तो ए दीटा कांसेप्ट के मन रखियो तार so this is an important judgment कौन कहलो कोटा कहलो हां पर सब्सटेंटिव इक्वालिटी कथा कहली आउट कहली पॉजिटिव सेक्युलरिज्म एक्चुअली पॉजिटिव सेक्युलरिज्म इन द कांसेप्ट इन हाई वेस्ट रे प्लीज नोट डाउन तांकर सेक्युलरिज्म द वेस्ट एंड सेक्युलरिज्म आसुची माने वेस्टर्न कंट्री रे सेक्युलरिज्म माने पर्सनल रिलीजन एंड स्टेट आर इंडिपेंडेंट थिंग्स प्लीज नोट डाउन रिलीजन इज एन इंडिविजुअल परस्यूट तमे कहा को पूजा कलो पूजा न कलो तमर एटा इंडिविजुअल परस्यूट state has nothing to do in the procession curriculum. This is all a matter of faith. Faith is very personal. In case of India, we do not look at faith as an individual thing only. It is a community pursuit. So that is how there is a difference. There is a risk. Anyway, so again, eta ota dekha AMU as a minority institution. Eta again one area where a question is likely to come. नोट करो भल करी जो माने सब दौच परीक्षा 100% दिस इज एन इंपोर्टेंट केस दिस इज ए केस इन्वॉल्विंग नरेश अग्रवाल वर्सेस अलीगढ़ मुस्लिम नोट करो तू जोड़ा सब कहूचे टिके नोट करो जेतले पाइबो मते से तापरे तुम कहबो जे सर एटा कहितले भलो करथले जानिबो ता हैला सो ए केस रे कोन हला मेन कथा होची there is a judgment of 1967. Please note down 1967 called the Aziz Basa judgment. Aziz Basa judgment of 1967. A judgment re Supreme Court said the Aligarh Muslim University was set up. This was set up by Syed Ahmad Khan in 1920. Please note down. In 1920, 1900 जो मैंने हिस्ट्री तो हिस्ट्री पढ़ছো तो मॉडर्न इंडिया पढ़ছো कि नहीं सो ये जो अलीगढ़ मुस्लिम यूनिवर्सिटी हैला दैट वाज इन रेस्पॉन्स टू द बनारस हिंदू यूनिवर्सिटी हमर जो बनारस हिंदू यूनिवर्सिटी की करथला मदन मोहन मालव्य सेट अप द BHU and in response this guy Syed Ahmad Khan set up the Aligarh Muslim University. Tankara main objective thila he said that you see the Muslim he told the Muslim community tame dekho jette सब भलो post रे खाली हिंदू माने अछंती because they have availed of western education तमे जेहेतु सला ए जो कोन कहला तमे this kind of things माने मद्रास रे पढुचो तेणु तुम किसी चाकरी पाउन आइदर मोची हेच कि टेलर हेच कि गीत गाउच कि बीणा बजाउच कि कुक हेच बुझो तो से कहला तुम टी पढ़ापढ़ी कर भल पढ़ापढ़ी कर भल यूनिवर्सिटी पढ़ापढ़ी कर ताहले जाकरी मोतीलाल नेहरू भलिया वकील बनिबो नेहरू भलिया वकील बनिबो नले तुम एमती माड़ खाई बसिबो खाली सो दैट इज हाउ एपी वाज सेट अप इन 1920 ओके नाउ जेतेबेले इंडिया इंडिपेंडेंट हे गला सो now the question came India independent he gala that act was superseded by the UGC act please note down UGC took over that university 1956 re there UGC hala University Grants Commission hala so it took over AMU so the question came will it have a minority status? Minority status advantage ta kono? You can set your own syllabus. Please note down. You don't require approval of the UGC. You set your own syllabus. You set what are the admission procedure. You set what pay and allowances you will give to your teachers. Complete autonomy. Please note down. When you become a minority institution, when you become a minority institution, you have complete freedom in fixing your syllabus, in deciding entrance, kete tame Musalman nabo, kete Udiya nabo, sabu sitrai paibro, and then also pay and allowances. You are not regulated by UGC guidelines. There UGC guideline कहबो तमे यदि PhD न होबो ताल तमे रीडर हे परिबो नाही कि तो माइनॉरिटी इंस्टीट्यूशन को नाही तमे so you can deviate from that. Are you getting my point? So Aziz Basa case re 67 re the Supreme Court said sir apangra se minority status nahi बुझलो तो तुम से माइनॉरिटी स्टेटस नहीं, that minority status is over, sir. Over. So now the Supreme Court again मुसलमान भक्ति केमती हला से कहले नाइ. So से कोचे minority status is not surrendered upon incorporation in the university. Please note down. Just because a new University Act has come, the minority status will not evaporate automatically. It will mondako eta question aswa chance achi. This is a likely question. After independence, when you have a UGC Act, that does not automatically supersede the minority status of a university. So therefore the court said, so we have to find out. We have to find out whether the minority community established the institution or not. Please note down. It is the main issue. The institution is established hala, कितने बड़े hala, independence पूर्वरु hala कि परे hala. So we have to determine whether the institution was actually established by minority and funded by them. Please note down. Not only established but also funded. पैसा किए दला? मुसलमान माने दले ना अन्य माने के देइचंती किए देइचंती? Who has contributed to that? मैंने स्टेटमेंट के देना है सब ये जो 20 लाख टका. Please note down. Muslims collected 30 lakh reserve fund. अरे 30 लाख टका शायद हम काम कलेक्ट करके इन्वेस्टर स्टार्ट कला 30 लाख टका कला सर स्टेटमेंट किसी देना थी. अलीगढ़ मुस्लिम जो यूनिवर्सिटी हला 30 लाख टका देकरी सर इन्वेस्टर को बनेले. So the Supreme Court said, let us look into the records and let us find out whether it was founded by Muslims or not. The report to the Katha. Have you understood this? Have you understood this or not? So earlier judgment was based pure on a technicality. अरे इंडिपेंडेंस हला नुआ एक्ट असला रफा दफा हे गला कोर्ट से मैंडेट है उनको नहीं अरे ए जो अच्छी जो सुप्रीम कोर्ट रो जो प्रीति अच्छी मैंडेट इंस्टीट्यूशन माने सेटा दिस इज कॉल्ड द एटा टिके नोट कर एटा एक क्वेश्चन टा एएमयू वर्सेस नरेश अग्रवाल. आ गोटे देखो एउडा सब टिके lesser known cases बुझो तो गोटे जरा lesser known case भी गोटे important case आसीबो आ गोटे गूगली टाइप रो गोटे जरा क्वेश्चन आसीबो. एटा होची upholding section 6A of Citizenship Act. बुझलो तो एथरे बेसिक इश्यू हला जो गवर्नमेंट ऑफ इंडिया. प्लीज नोट डाउन. गवर्नमेंट ऑफ इंडिया जो 6A गोटे इंट्रोड्यूस कला सिटीजनशिप एक्ट ऑफ असम. प्लीज नोट डाउन. सिटीजनशिप एक्ट. प्लीज नोट डाउन. the government, the parliament has full powers of declaring who is a citizen. Citizen रो जो criteria अरे गवर्नमेंट ऑफ इंडिया रो फुल पावर अच्छी अंडर सेक्शन अंडर आर्टिकल 326. Okay, so therefore the question was जो असम अकॉर्ड रे हला जे जो माने immigrants of Indian origin who entered into Assam before 1166 will also be considered to be citizens. जो मन सब बाहर आसिले जो माने immigrants आसिले, so they would be considered to be persons of India. And then it also said that between 1166 and 71, that is March 71, they will also be deemed as citizens. Please note down, citizenship was determined as on 15th August 1947. Please remember, when India got independence, that is the cutoff date for citizenship. So you cannot become a citizen. So if you want to give flexibility beyond 15th August 1947, the parliament has to make an act. Are you all getting me? बुझु के कथाटा तमे जदि सेथरे फ्लेक्सिबल पार्टी माने if you have stayed on the other side, so you cannot again claim citizenship in India. So a flexibility को असम रे दिया ही because lot of immigrants have come in. So एटा ठीक के नुहा बुझलो तो ठीक के नुहा सुप्रीम कोर्ट कहला एटा ठीक अछि. Again this is a controversial decision, but this is a decision the parliament, so Supreme Court has said that it has power, so it has given. कौन था against it? What is the argument against this particular thing? मत कहला. The demography of Assam would be affected. Demography of Assam माने कौन हबो ना जदि माने सब disproportionately Muslims माने हेबे ताले जो माने सब natives अछंती से मानकर rights affected हबो. So यदि vote देबे ताले से माने कौन हबो. So this will basically favor that party which has got sympathy of the Muslims. Are you getting my point? Amo desare there is one more state which has benefited very significantly out of this. Can you tell me which state? Yes, West Bengal. Which state has benefited very significantly? Which party in India? Co-state West Bengal. West Bengal re प्रथमे CPM जो 5 पहला vote, it was basically by protecting the interest of the Muslims. The percentage of Muslims in Bengal is 35%. Please note down 35%. 35% होची मुसलमान. जी मुसलमान मान को टेक केयर करी से मंत्री से हला तांको तो छड़े न लाओ ज्योति बसुटू ममता बनर्जी कौन बुझो तो कथा जो कथा है मोदी सरकार करे चेष्टा करछन जे सब हिंदू मान को छड़े नहीं गिरी से राजनीति करे चेष्टा करछन. Same माने same politics of religion. So same also in Assam the same thing is there. It is predominantly the Muslim vote which matters in Assam. कि जीतियो कांग्रेस भाबितला सबले जीतियो बोली किंतु से जाननतले जे मोदी सर आसिकरी किमती ताकू. So this is another. Bulldozer justice, again this is one thing which can come. Bulldozer justice. A judgment mainly teaches Justice Gawai, who is going to be the next Chief Justice of India, Justice Gawai. Gavai, Justice Gawai. This is considered to be a very important judgment. Please note down, this is considered to be very, very, again, okay, likely question. 6 eta jo last purpota kahili seta unlikely, but this is a very important judgment. So, eighth question hochi, the no property can be demolished solely because the occupants are accused or convicted of a crime. Please note down, this is the basic thing. If somebody is been convicted of a crime, you cannot demolish the house. Jimti ebe heichi tagar gharoda bhagi dichin kar galo ebe dimale gharoda ebe jo stay dechi jo high court stay dechi. So this happened in UP. So now the judgment is that the executive cannot replace the judiciary in performing its core function. So the judgment is that there are 3 organs of the government: judiciary, executive, and the legislature. Judiciary kamo hala se koibo eta thik katha ki nuho. So you cannot, so demolition cannot be a punishment. Please note down. You cannot do demolition as a punishment because right to shelter, please note down, right to shelter is a fundamental right. Right to shelter. Co judgment re. Olga Tellis. Very good. Give her a big hand. Olga Tellis case re. Right to shelter is a fundamental right. Right to life. Okay. Right to shelter. Right to having a shelter is a fundamental right. Okay. So no demolition can be. So now the court has set a few guidelines before demolition. Please note down. It has set a few guidelines. First kotha hala je the executives cannot take over a judicial function. Hala? The executive cannot take over a judicial function. And secondly, right to shelter is a fundamental right under Article 21 as per the Olga Tellis judgment. Olga Tellis judgment. So, if you want to go for demolition, there are a few guidelines. Pratham guideline, due process is required. So cause notice should be there, and there should be time for challenge. Pratham kathala, you have to give a due notice, and secondly, you have to give a time for challenge, and all these things should be part of a digital portal. Okay. Not applicable to unauthorized structures in public places. Please note down. But demolition of structures, unauthorized structures in public places will not attract this. Bulldozers can demolish an unauthorized structure in a public place. Tome jo girja karicho gote public road upare, it can be demolished. Are you all getting me? You can do that. If it is an unauthorized temple also or a church also, it can be demolished. So if it is an unauthorized structure in a public place. So please note down here. Note correct. Here the judges have invoked the public trust doctrine. Please note down. Here the judges have invoked the public trust doctrine. The Kamakurni Penta. Public trust doctrine. Public trust doctrine hala. This is a doctrine which is there for every civil servant. Please note down. OS paila pore tomar you are governed by a public trust doctrine. This is a doctrine there as per L. Dicey. Dicey hochi got a famous. So kochi that you will faithfully discharge duties. Please note down. To elongate public trust. Please note down. Public trust doctrine hala, you will faithfully discharge your duties to elongate what? Public trust. So that people's trust in you increases. Tame emiti karibo jemiti public trust tama upare rahibo. So like in the UK, people have a lot of trust in the police. Police are very, very helpful. People will go to the police. Amar 80 police will police mada khayeva katha paisa khayeva. So there is no trust at all. Okay. So are you all getting me? So it invoked, please note down, it invoked its power under Article 142. Please note down. It is a direction to the state under Article 142. 142 कौन article था? That means all its instructions are binding. खम खेले नहीं है बनी, नाले जेल ही जो. Article 142 जितल तमे invoke कला, ता माने तमरो accountability रही then there would be contempt of court. You will go behind bars. If you are not giving a notice, if you have not given them a time to reply, then you can be in a serious suit. So this is a very important judgment. Hello? Eight another case तुम मन रखो एवढा टिके मने रखिले जाइकिरी श्योर शॉर्ट मेन एग्जामिनेशन पाइबो सुकन्या सांथा वर्सेस यूनियन ऑफ इंडिया सुकन्या सांथा वर्सेस यूनियन ऑफ इंडिया कौन से केस टी कहले टिके सर कहले सब तो जानथिबे सर सुकन्या सांथाटा किए हुई सुकन्या सांथा अरे तुम गोटे झील पिलाटे से सुकन्या सांथा किए से गोटे एक्टिविस्ट सी इज एन एक्टिविस्ट सो सी वेंट अराउंड द प्रिजन्स एंड शी फाउंड आउट वेरी इंटरेस्टिंग she went around the prisons and she found that in the prison certain works are given to prisoners based on their caste. तुम यदि चमार हलो तुम काम हला झाड़ू मारिबा तुम यदि ब्राह्मण हला तुम रोसे करिवो and she found out no I'm not joking she found out that the prison manuals also provide for this. Please note down. This is very note hostu chosna ita question asibo. So Sukanya Santa dekila it sanctioned discriminatory caste practices from marginalized community. अरे बुझो कि नहीं तुम भाबो केते दुखर कथा ए देश रे so prison रे also activities are based on caste. So quite some time जेतबडे ये आरंभला midday meal scheme हला so people like John Drage and Ritika Khera they found a study जे जेते सबु सोला परिया पत्र काटिवा झाड़ू मारिवा सबु सोला शेड्यूल कास्ट पिला this some of those practices still there तांकु गरीब पिला को तांकु झाड़ू मार रे so not only this was a practice, please note down, it was also part of the prison manual. So, are you getting my point? So any classification made by law has to, any classification should promote marginalized class. So this classification of prisoners based on habit, custom or mode of living is not acceptable. So कौन direction देइचंदी first कथा होची deletion of caste column please note down so what are the direction have you understood Sukanya Santha brought to the notice of the Supreme Court the pernicious practice of discriminatory work based on caste being in vogue in different prisons and sanctified by the prison manuals. Kim sentence एमती लेखिले जाएगिरी फुल मार्क मिलियो कौन सी नोटिस सी फाउंड प्लीज राइट डाउन सी नोटिस्ड discriminatory practices based on caste system which was also legalized in the prison manuals, which was also legalized in the prison manuals. So the Supreme Court has struck down, has asked the government, please note, the Supreme Court has asked the government to delete all these provisions from the prison manuals in 6 months. Please note down. I consider this to be one of the very, very important judgments. Buchcho to? Arey, Panda buchcho na nahi. So the Supreme Court has given a direction that in 6 months' time, all this caste-based discrimination within the jail premises must be deleted. They have also said, delete the columns which ask you to specify your caste. Dhamma, Chamana, Brahmana, Kshatriya, Poita Achiki Toro. We used to have teachers Can you believe we used to have a teachers? I remember in 1969 when I was a student in intermediate science. So setu kale tame sen Mishra tomar poita kai? Unko sir poita ko mu Mahanadire phopad dechi. Se to bamon pila no, muke nai mu bamon pila no by conviction. I don't use a threat. Are you getting my point? So he was dismayed. Are Brahmana pila gota poita pokevani ki kotha tame gota. This is the kind of prejudice we still have. Are you getting my point? This prejudice still we have. It's a very sad thing. So the court has said that all these discriminatory practices must be deleted from the prison manuals. They have also said that abolition of all caste-based privileges. It has said that the objective of the government should be how to improve the conditions of, please note down, how to improve the conditions of the marginalized class. How to improve the conditions of the marginalized class inside the prisons. How to the case karo je kisi korna nanti boli again taku mada hobo 142 re mada hobo. Supreme Court will issue a again PIL will have to be filed. Supposing they don't do it, it's a very, very good question. There have been many instances like that. Please note down, it is called continuous mandamus. Please note down, it is called continuous mandamus. What question? Very good question you have asked. This is called continuous mandamus. Our article 32 achi, please note down, article 32 achi. So one of the provisions of writ is mandamus, where the superior court gives an order to a lower court or a lower authority. Please note, this is called mandamus. Are you getting my point? In 93, Supreme Court found that there are many orders they were issuing under mandamus, which are not being complied with. They found that there are a number of cases where the government is coolly sitting over it, not taking any action. So this gave rise to a concept called continuous mandamus. Continuous mandamus mane barambar order debe. So it is not as if that once you have given order, it has gone into thin air. So what she says is, yes, continuous mandamus. It is. So court kahila first kotha la je tame emti gote discriminatory practice jail re kari paribani. On the other hand, the court said je tame jo mane marginal community achanti, how do you behave in a sensible manner, human manner to them, so that they also think that they are equal to the others. Are you getting my point? It is beautiful. It's a very, very good judgment. It's an extremely, extremely good judgment. There's another lady who did a lot of work on this. Her name was Sheila Varse. Please note down. Sheila Varse. She died a few months back. Sheila Varse. जी कहीदेव शीला वर्षे ऑनलाइन रे किए कहीदेव कौन एक तार कंट्रीब्यूशन कौन अच्छी शीला वर्षे जी कहबो ताको 500 टका देती शीला वर्षे. One of the ladies I had the good fortune of meeting in Bombay. Okay, she was a lawyer. She was a lawyer, and jitne under trial prisoners got rights. How female prisoners got right. Please note down. Sabuto the maximum kamo karchi se hochi Sheila Varse. She went around the prisons and he found how the children and women were being maltreated inside the prisons, and how she found how women were being unfairly treated in the police lockup rooms. It is because of her report that lot of reforms have happened in treatment of under trial prisoners. Under trial prisoners children, women, ये syllabus. So what I want to tell you जे आम देश रे एम सब लोक अछंती ओल्गा टेलिस गोटे ओल्गा टेलिस कोन करतला ओल्गा टेलिस जो स्लम डेवलप तो बाहर कले से तो से पर्टिकुलर कले स्लम डेवलप तो बाहर करछ कोन पे राइट टू लाइफ तक रोड अछि मेधा पाटकर से भी सिमति त नर्मदा पढेले सो ए देश रे जते सब भलो मूवमेंट हेची तमे पुओ पिला माने करना सब झियो पिला सिलेबस से नो आई एम नॉट जोकिंग सब मेजर कथा उडाका से स्थिर लोक पढाई करछ आर यू गेटिंग माय पॉइंट तुम माने खाली हल्ला करी खाली काम केमि करेबा से चक्कर सोच किंतु वेरी वेरी गुड जजमेंट सुकन्या संथा वर्सेस यूनियन ऑफ इंडिया कोडा 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 अपन 6 मास करे पे डायरेक्शन दिछंती within 6 months they have given a time limit of 6 months to every government to review their prison manuals so that these obnoxious provisions about discriminatory work practices based on caste is done away with eta hochi sukanya santa eta mon rakito eta aswara chances achi this is the last case for 2024-25 okay eta hochi permanent commission to women in defense services permanent commission to women in defense services eta hochi so in 2020 so this was given under article 24 under 14 tapre so basically ei jinsata mane the lady please note down there was a wonderful justice in US her name was Justice Ginsburg तमटे YouTube जाई करी ते देखिबो Justice Ginsburg ए स्त्रीलोगटी she died of cancer she hardly her voice is audible but she has almost 10 to 15 million followers on YouTube and she is a wonderful judge she you women equal rights she was the person who ensured entry of women into defense academies in the US guru America re defense academy re women were not allowed so similarly why amar DY Chandrachud also is responsible for entry of women now into the NDA so anyway this question will come so to cut the long story short we'll go to the previous ones also to note kara tike ei jo 12 ta judgment deli ei thre tike मन रखो जो मन रहिले हाँ एथरे मन रख माडा वर्सेस सेल एटा 100% मन रख तापरे प्रॉपर्टी ओनर्स एसोसिएशन तापरे डॉक्टर बलराम सिंह बुलडोजर और कास्ट सेग्रीगेशन इन इंडियन जेल्स मोर धारणा एथरु गोटे क्वेश्चन आसु हैला आउ आई सजेस्ट तुम जो मन सब लिखुच एटा करो टैक्सेशन ऑफ माइंस टा करो जने तापरे बलराम सिंह टा करो एटा करके तीनटा चारटा खंडे तमे आंसर करो जोटा कहली जो मन सब दोचो मेन परीक्षा दोचो आंसर करो इट विल बी गुड फॉर ऑल ऑफ वी विल नाउ गो टू a few more important judgments before this okay अब 15 मिनट की जोस्ता नहीं तो are you fine with we'll quickly go through the landmark decisions गोटे पर गोटे आरंभ करो अने गोटे तो जानि थिबो तबे एटा को गोटे पिक्चर नहीं जा तुम आराम रे एटा को रखि तो ताले तुमको सुविधा है जो बुझले तो फर्स्ट रे हला Keswananda Bharati case 73 एटा नियो पिक्चर नियो गोटे पर गोटे तमे एइथरे बेसिक स्ट्रक्चर डॉक्ट्रिन आसला तापर नोट करो एडीएम जबलपुर रे कौन जजमेंट थिला कौन थिला जजमेंट इमरजेंसी समय राइट टू लाइफ नहीं प्लीज नोट डाउन इमरजेंसी समय राइट टू लाइफ नहीं एटा ए जजमेंट कोर्ट जजमेंट रे सुपरसीड हला राइट टू प्राइवेसी को जजमेंट पुट्टस्वामी केस so please note down in Puttaswamy case this judgment has been overruled. Is it clear rahla Rina? ADM Jabalpur judgment hela जे emergency समय तमरो right to life नहीं you can be arbitrarily arrested without showing any reason during emergency. When Article 352 is in operation, you can be arrested without assigning a reason. This judgment has been overruled in the Puttaswamy case, where they have said that right to life exists. So this is a case where the son has overruled the father. Please note down. This is a case where the son has overruled the father.
सर एटा जोटा एडीएम जबलपुर वर्सेस शिवकांत शुक्ला ना
शिवकांत शुक्ला एडीएम जबलपुर
हाबियस कॉर्पस रहतला
हिबिस कॉर्पस ऊपर रहतला वेरी गुड एडीएम जबलपुर वर्सेस एसपी शुक्ला was arrested. Shukla was a journalist. He was arrested in 1977 during emergency without assigning reason. So his wife went to the Supreme Court saying that please produce the body. So Shukla died in prison. There are many people who died during emergency in the jail. Many people. So that was ADM Jabbu. Taparala Olga Tellis. Olga Tellis kaun hala? Right to life and shelter. Please note down, this is the first case where second generation rights, please note down, second generation rights, where second generation rights have been introduced. What is a second generation right? How do you keep war? What is a second generation right? Anybody else? Fundamental. What is the second generation right?
Socio-economic right.
First generation right are rights which are part of the constitution. Please note down. Any right which is guaranteed by the constitution is a first generation right. That is, so any right which has been created by the court is a second generation right. And mainly it is around Article 21 and Article 19. Common about the second generation right manala socio-economic rights. No. Second generation right hala rights which have been given by the Supreme Court through their interpretation. Please note down. This is many students make this. जो rights गुड़ाक संविधान रे अछि, these are all your first generation rights. There are many judgments which are there, but which are not incorporated in the constitution. Like right to shelter, is it there? Is right to health there in the constitution? But it is a second generation right. So you invoke that. When you go before the Supreme Court, you invoke that. That's our upon judgment. Are you good? Second generation right is not socio-economic rights. So second generation rights are rights which are amplified. Please note down. Amplified the scope. Second generation rights have amplified the meaning of right to life. Right to life. If you read the constitution, one would get a feeling that you can live like an animal. You have a right to live like an animal. So the Supreme Court has said that you can live with a dignity. Please note down. When that is your second generation right, not what you are saying. Right to live with a dignity as per UN Human Rights Declaration. Please note down. As per UN Human Rights Declaration 1948 is second generation right. अरे बुझो कि नहीं टिके भलो कि से फिजिक्स से चलिबो नहीं टिके चलिबो ए जो टिके संविधान को जोग पड़िबो राइट not only right to life, right to live with a dignity. And dignity किमते आसीबो shelter हवा दरकार, education हवा दरकार, clean water दरकार, भलो shelter दरकार. These are all if you want to right to livelihood दरकार. बुझो ना नहीं 8 to expand करूची. बुझो तो कथा. So basically it is an expansion of Article 21. How किसी ने को article law expand in Article 21. How you read? What is your reading of right to life? Now, right to shelter, please note, co-constitution achhi pura explicit provision. South Africa, please note down. South Africa has this provision. Explicit provision. So many people say that South African constitution, which is drafted by Nelson Mandela, is one of the most progressive constitutions in the world. Right against torture, please note down, right against torture. And compensation for that should be a second generation right. Right against torture and compensation. कहीं पर ये तो कहीं तो दिखा ऑनलाइन में पिला अच्छा कहला देखिए right against torture and compensation for torture and death. whose judgment है था? What तुम्हें भाषिल এটা ওড়িশা ওড়িয়ার গোটে পিলা নীলবতী বেহেরা give him a big hand নীলবতী বেহেরা কেবের এটা very good give him a big hand নীলবতী বেহেরা 1993 this is এমতি কইলে যাইকি পাইব নীলবতী বেহেরা 1993 প্রথম কথা হলো custodial death উপরে 1993 রে for the first time how would important the judgment hela ti mon rakhre baba how would important hela je police people are also not immune to punishment please note down se parjanta thila tame jodi police hegri maribo to guna taku mar do bana to mo sir police inspector mar dili mote kichhi nahi so for the first time Supreme Court said that if you have been instrumental in the death of somebody in the custody you can also be hanged. आगर जो थिला जे तको माने मारी दिबी तको सर पिटिपुटु मरी गला मु कोनटा करिबी जे पिटिपुटु दे मरी गला ताले फांसी लागि जार चांस अछि ठीक है मन रही तो संग्राम ए सब बड़ असुविधा कथा अछि इच नीलबती बेहरा अरे बुझछो कि नहीं नीलबती बेहरा सो एटा हला ओल्गा टेलिस तापर असला साहबा जानथिबो कोन हेतला CRPC over personal law तापर उन्नी कृष्णन right to education इंदिरा साहनी 50% cap on reservation SR बोमाई floor test तापर श्रेया सिंगल free speech in electronic media को section रे इतरे struck down हला
section 66 IT Act.
66A of IT Act was struck down. 66A of struck down. तो उठे पचाउची किए को जज एटा देइथला कहि परिबो तो कहि देबो ताल जानिबे जे तो आस पाइलो पक्का पाइबो जी कहबेटा पाइबो जस्टिस नरिमन प्लीज नोट डाउन जस्टिस नरिमन भारत रे देयर आर सम जजेस हु आर नोन फॉर ग्रेट जजमेंट प्लीज नोट करो जिमिति एडीएम जबलपुर रहला जस्टिस हंसराज खन्ना प्लीज नोट डाउन जेतल तमे लेखु छै विषय तमे यदि को जज का ए जजमेंट में देई चिता नाडा देबो तन आउ टिके बढ़िया तोरो जस्टिस खन्ना साहबानु किए कहि परिबो कोन हेई छि आज तमरो वाईवी चंद्रचूड़ प्लीज नोट डाउन वाईवी चंद्रचूड़ तापरे श्रेय सिंगल रहला जस्टिस नरीमन। राजनारायण वर्सेस इंदिरा गांधी कौन था? रूल ऑफ लॉ आर्टिकल 329A was struck down. What is article 329A? Konta? Elections of prime minister cannot be reviewed by the court. So this was struck down. Which amendment was struck down? बढ़िया पूछो तुम्हें, बहुत बढ़िया पूछो। Which amendment was struck down? कोई डाउट नहीं है, पूरा पसी है जो डोर खोला ही है फिर तू बस जा। 30? Give him a big hand. 39th amendment. एमती हेले जाएगी पशु ता भितर जाएगी पशु। कौन 39th amendment देखो तो 39th amendment से कहला रूल ऑफ लॉ। एटा किए था जिसला को जज नाटा टी कहले टिके हैं को तो बड़ा को तो चेष्टा करे टिके भलो माने खूब भलो ताकर ना अछि पब्लिक इंटरेस्ट लिटिगेशन प्रो फादर से जस्टिस भगवती पीएन भगवती भारत रे दीटा जज गोटाला कृष्णा आ गोटा भगवती प्लीज नोट डाउन जस्टिस भगवती आ जस्टिस कृष्णा गरीब रे माने होचंती साथी maximum judgments and they are also in favor of directive principles superseding fundamental rights. Please note down there are only two judges in India. Ki Bhagavati और जस्टिस कृष्ण है मु थर तंग फ्लाइट रे तंग संग जाउतली भगवती के से भगवती के संगे पुरा संगे जाउतली तार भाई होचन जने होचन खूब फेमस इकोनॉमिस्ट जगदीश भगवती मु तो कहली मुकिल सर आपने बहुत अच्छे जजमेंट दिए सी वाज सो हैप्पी आउ कहबार ने बहुत हैप्पी वेरी हैप्पी मुकिल सर योर ब्रदर टॉट मी इन दिल्ली स्कूल ऑफ इकोनॉमिक्स के ही इज अ वेरी फेमस इकोनॉमिस्ट अरे बढ़िया लोक से बढ़िया लोक मिनर्वा मिल्स केस कोन हला मिनर्वा मिल्स केस रे को आर्टिकल ता स्ट्रक डाउन हितला दिया कहले टिके कह दबो तमे मिनर्वा मिल्स केस रे को आर्टिकल ता स्ट्रक डाउन हितला कौन है तुम सबू वो which articles were struck down कौन पंडा होची सबू अरे there are two amendments to article 368 which were struck down by Minerva Mills case. What are they?
The 31C.
ना एकदम भूल को 368(4) and 368(5). Please note down 368(4) or 36. In the 42nd amendment, please note down in the 42nd amendment in 1976. In the 42nd amendment in 1976, Mrs. Gandhi introduced two articles, two subsections to article 368. 368 कौन? Power of the parliament to amend the constitution. 368(4) कहला जे parliament can amend any provision. Please note down. Parliament can amend any provision. 368(5) कहला the judiciary has no power of judicial review. हमरो जो चंडी इंदिरा गांधी कहले जे पार्लियामेंट रो फुल पावर मु जहा कहबी सेया होबो इंदिरा इज इंडिया इंडिया इज इंदिरा जहा कहबे आउ judiciary has no power to review. Both these things were struck down in the Minerva Mills case. Please note down with this judgment 1980 रु जिते पॉलिटिकल पार्टी आछंती आउ से विषय से उठो नहती पठा अरे बुझो कि नहीं बुझो कि नहीं 1971 रे she amended the constitution saying that I have full powers, no judicial review. माड़ खाइला केबे 73 रे please note down the history. 71 रे she said that Supreme Court has no power to judicial review. I have full powers for amendment. That was struck down in the Kesavananda Bharati case. छह स्तर से कहला से शांत हलानी कोट शांत हो से कहीं शांत हो से कहला जे नाई again she invoked that and 1980 रे से माड़ खाइला and this is the most important judgment. Please remember, this has not been challenged in the Supreme Court, this concept. So therefore, please remember that Parliament has limited powers. Parliament has limited powers. It can amend fundamental rights, but it cannot amend the basic structure. Is that clear? And the Supreme Court has power to do a judicial review. कौन जुडिशियल करिवो जुडिशियल करिवो जे whether it is reasonable or not. Reasonability किए डिसाइड करिवो. So that is your Minerva Mills case. Bisakha Rani case टा कौन हो? Sexual harassment in public place. Last table का असर तुम्हें देखो है ना ठीक है. रमेश थप्पर, please note down. रमेश थप्पर हला 1950 रे freedom of press. Please note down, freedom of press started with Ramesh Thapar case. 1950. जेतेबेले 1950 रे जेतेबेले they tried to limit the number of pages in a newspaper, reduction in the number of pages. So the Supreme Court said nothing doing. So this is against freedom of press. A.K. Gopalan case टा की कहि परियो मते? A.K. Gopalan case, preventive detention. So if you have been arrested on preventive detention, under which article? 22.
20 plus 2.
Article 22 हला preventive detention. So preventive detention हला से कर देटा हनीफ क्वेरेसी केस की कहि परियो? मन पड़ची कि कोहट के यदि कहबो तो मु जानिबे जे रिना एकदम पूरा बहुत मन रखी छे. हनीफ क्वेरेसी केस देखियो ऑनलाइन रे की जानि पड़ची. It's a very important case on cow slaughter. Please note down, cow slaughter. This is considered to be the most important case on cow slaughter. A judgment रे देतला जे तमे जो cow गुडा को those which are still in good condition, you cannot butcher them. But if they have outlived their life, that is beyond 14 years, there can be a slaughter. So this judgment permits cow slaughter beyond the age of 14, but not below that. So ither kon hala, how did, so please note down, this is a case which balances fundamental rights with the directive principles. Please note down, this is a case which balances what? Fundamental rights with directive principles. Directive principles at Article 46 says, je tame cow slaughter should be avoided. Article 46. So, and Article 19(1)(g kahuchi, je you have a freedom of right to trade and profession. So, so please note down, Hanif Qureshi case is a case where the Supreme Court has tried to balance directive principles with fundamental rights. Okay. Taprala, Nilavati Behra already have mentioned custodial death. Nafte Singh, decriminalizing homosexuality, and Selvi case. What is Selvi case? Selvi case, you cannot be forced to give witness against yourself. Please note down. You cannot be forced to give witness against yourself. So lie detection test is unconstitutional. Lie detection test is unconstitutional unless you give your consent. तुमको जबरदस्ती से पी परिवेनी, कभी तुमको जबरदस्ती कर परिवेनी. That is not admissible in the court. Supposing you have been forced to give a confession, confession. So lie detection test was frowned upon. Tapare Sabrimala case, all of you know, temple entry and Puttaswamy hela right to privacy. So we go to the last slide today and we end with this. It would have photo reja. It a photo no. So let us look at Supreme Court. Let us look at Supreme Court in retrospect. How do I look at the Supreme Court? If somebody asks me, how do you look at the Indian Supreme Court? Please note down that when the Supreme Court started, from 1950, please note down, friends, from 1950 till 1967, from 1950 to 1967, the Supreme Court was a very conservative court. Where it went by procedural compliance please bujheo chesta karo. The approach of the Supreme Court was, when a case will come to the Supreme Court, they will basically try to see whether the government has followed the right procedure or not. Same thing procedure established by law. Please note down. Procedure established by law. The hostel you have been given a notice and you have also given a reply. So if the court finds that you have been given a notice and you have given a reply, then it is fine. Have you understood my point? Kintu, Justice Bhagavati changed it from procedure established by law to due procedure. Whether it has been fair or not. Have you understood? So supposing you hospital, so notice the court will go beyond the procedure. Court will try to see whether it has been fair and not arbitrary. Please note down. Fair. So court main test fairness. Please note down. Fairness, lack of arbitrariness, and non-discrimination. Tinta kotha. Kotala fairness, kotala lack of arbitrariness, and non-discrimination. Ei tinita godo upare judgment hiyaich. It has a due process. Due process ame kon koche? Whether it has been fair, whether it is arbitrary. Arbitrary mane kono? You are not following in law. Mu kohuchi. Sitna hala. Are you all getting me? So that is fairness, arbitrary or non-discriminatory. You are not discriminating between communities, between religion. 8 hala. So before 67, please note down, before 67, all judgments followed what is known as procedural compliance. Odisha society masere ko judgment hitla? Goloknath case. So Goloknath case re sir, Supreme Court कहला the fundamental rights cannot be amended. You cannot touch the fundamental rights. Because part 3 article 12 कोची जे you cannot amend it. So माने जहाँ text अच्छी, they followed the text and interpreted that. But they did not go into the merits of the text. Are you getting my point? Please try to understand. Whether the text is fair or not, So therefore गोटे हला procedural compliance आ गोटे हला merits of a public decision जो public decision ने हला whether that is a meritorious decision what is a fair decision so एटा हला so तापरे we had another right of center so most of the judges were right of center but in the 80s with the coming of Justice Krishna and Bhagavati the judges went left of center जो की directive principles were given precedence over fundamental rights बुझु तो कथा before these two judges fundamental rights preceded directive principles part 3 prevailed over what part 4 किंतु 80s पर जो particularly तो जो कौन टा है ना हमारे केशवानंद भारती केस पर 73 करो माने 73 पर it is a left of center so directive principles are prevailing over fundamental rights हला वर्तमान हला centrist ये माने ना मजिया so Chandrachud's and all they are all centrists so distributive justice रहइबो किंतु with restriction बुझी पड़छ तो गोटे पहला जे property can be all taken away गोटे हला property cannot be taken away and there is a centrist viewpoint which says property can be taken out with restrictions are you all getting me so therefore the pendulum has swung from right to left now to the center are you all getting me तापर हला basic structure होची so most important doctrine एपर तो जिते जजमेंट देची सो मोस्ट इंपोर्टेंट बेसिक स्ट्रक्चर डॉक्ट्रिन एक्सपेंडेड व्यू ऑफ राइट टू लाइफ जोटा कहिल तुमको जोटे के हमें सेकंड जनरेशन राइट तापरे वी आर आल्सो टॉकिंग ऑफ सब्सटैंटिव इक्वालिटी दीस आर ऑल न्यू थिंग्स दैट देयर इज एडेड पॉजिटिव सेक्युलरिज्म प्लीज नोट डाउन पॉजिटिव सेक्युलरिज्म गोटला सब्सटैंटिव इक्वालिटी आ गोटला पॉजिटिव सेक्युलरिज्म How good is someone rakho? Please note down. Reasonable restrictions with the proportionality test. Please note down. Proportionality test. टिके मुंडा टिके बेसिक टिके सुनी दिया टिके. एटा हला आर्टिकल 19(1) रे कोन होची तो फ्रीडम दिया हिची 19(2) रे कोन दिया होची रेस्ट्रिक्शन किंतु रीजनेबल रेस्ट्रिक्शन ता की करिवो देखिवो सुप्रीम कोर्ट देखि से जो reasonability restriction टाको please note down reasonability will be tested through the lens of a proportionality test माने तमे जोटा एक्शन नेलाओ is it proportionate to the requirement अरे गोटे पिला दे मिछ कहला तमे ताको कोन 3 वर्ष जेल दबो have you understood so proportionality test means that the action taken is proportionate to the fault. Are you all getting me? You can put restrictions, but you know your action should not be disproportionate. Proportionality test ro dita katha la gote hala it should not be disproportionate and secondly tame jota action nocho it should achieve the result that you are expecting. बुझ तो it will proportionate test. तापरे welfare state and distributive justice without the sweep of socialism. एतिक हेला हमरो सुप्रीम कोर्ट रो सबु so that is the end of supreme court judgments बुझी गलो सबु इज हां पर क्लियर आईडिया आसी गला सबु से पेन टा खराब करी आनी छी किंतु लिखिया पड़िबोनी जिमती सेटा से बोलगा लेखे लेके न मो प्राणी खाइबे सर बने हैं प्राण खाइबे हैं ना थिबो बंसी ना जीवो ना रहेगा बांसुरी so anyway so तमने गोटे माने तुम जो मन सब मेन परीक्षा दोच तीन चारटा आंसर करी मती पठा let me have a look at your answers okay those of you who are also online please send me the answers okay and let me see how you are answering okay so तमरो कंटेंट रे किछि डिफिकल्टी नाही ठीक आर्टिकुलेशन टा उठे ठीक करो आ ठीक कंक्लूड इट प्रॉपर्ली है ना हां कौन कहला हाँ माने पॉवर्टी ऊपर तो हाँ मु बुझ पारली कथा अच्छे तो सब तुम गोटे काम कर तो साइट्स कौन ये तो पाइबो तुम एथरे तुम एगुड़ा गूगल कले पाउनो
सर एक पीडीएफ टिके सर सेंड कर देबे एडा तो नाही सर
पठे दवा तुम मत गोटे लिस्ट करी पठे दियो मु तार नोट्स रा पठे देबी किछ असता नै नॉट एन इशू तुम पठे गोटे काम कर तुम जहा सब मिसिकिर तुम गोटे मत पठे दियो तो डाउट्स गुड़ाक सो विल सेंड दैट
सर सेटा टिके डिस्कशन भी कर देबे ठीक अच्छे डिस्कशन दीपक सर टिके अलाउ करिया पड़ियो ना दीपक सर को कहू पड़ियो टिके सर आपण कहले सर
से होसने बहुत बड़ लोक तांको आपण टे कहबे ना कहले संगे हबो ना सर नले हौ ताले गुड नाइट टू ऑल
सर जस्टिस वर्मा को ऊपर टे कहबे ता जो केस ऊपर माने कोन एक्चुअली एबे जोटा चलची सर
हां नो सेइथरे में सुना मेन कथा होची जस्टिस वर्मा रा केस होची जे
करप्शन इन जुडिशियरी जोटा सर कांसेप्ट
1 मिनिट मेनली कथा होची एसेट्स डिस्प्रोपोर्शनेट टू हिज इनकम एटा होची कथा एसेट्स डिस्प्रोपोर्शनेट टू इनकम दिस इज द मेन इशू से जेति की वर्ष जज रहिचंती कि ओकिल रहिचंती सेथिरे तकर केते टंका हाई परथंता तकर केते टंका ता घरु मिलुची so assets disproportionate to the legitimate source of income basically it issue hochi je whether the parliament should have intervened or it should be done by the judges there is no provision today that the judges can form a committee inquire into this so many people feel that it may lead to delays but others feel that for the first time the chief justice is taking an action माने आगुर कोन होतला जत्ते सब होतला समस्त एमति खाली घोळोतले माने so at least he has shown some guts by appointing a committee taking a fact finding report and if that fellow doesn't obey then he'll report it to the government and the government tapar taku bajeva so unfortunately what is happening corruption judicial accountability is a very weak area today in the government of India, particularly constitutional judges, not other judges. Please remember, many times we think that judges are not accountable. That's not true. Up to decisions, they're accountable. And there is a mistaken notion that all judges are not accountable. No, it is up to it is only constitutional courts. Accountability of constitutional courts is the main issue, not other judges. It is another matter that proper investigation is not conducted against them. That's a different thing. This is paisa pato bahut khaus na kisi ke dhon nantal. Kintu constitutional courts as ki chori kala. Today it is a long run process, and most of the people do not call a spade a spade. Evla kotha hota hai.